I think it will take us approximately 9 to 11 minutes, and then we will take questions. I want to make very clear that the following video contains graphic images and can be disturbing for viewers. I say this now in this room, and I trust that each of you will accordingly warn your viewers or listeners of the same. Deputy Chief McMahon, thank you.
Thank you, Ms. Conover. What I intend to do is to go through the published video and let everybody know that although the published video that I'm going through and the video that's been released does not capture all the footage. I mean, there's countless hours of closed circuit television throughout the jail. Know that I've reviewed every minute of every camera of every digital image that's been captured in that jail. And I can tell you with reasonable certainty that the published video that you're all about to see today, again, as it's already been released, for those who have seen it for the first time, captures all the uses of force on the part of the involved correctional officers. Let me also say, as I stand before you as a deputy chief from the Los Angeles Police Department, my opinions rendered in this particular case are my own and not necessarily reflective of the opinions shared by the Los Angeles Police Department. I come here as an independent consultant given an independent review. So if I may, let's just go through the video, and I would like to illustrate some comments and share with you some of my observations about the incident. So right here at time code 1936, we can all see that Mr. Welsh is initially cooperating with the custody officers as they're escorting him up the stairs of the jail facility. He's cooperative up to the point they open the door, and the intention is to put Mr. Welsh into that cell. You can see at this point here, at 9:47, Mr. Welsh becomes non-compliant and provided what I've described as some passive resistance. You can see Mr. Welsh's arms in the air in a form of protest. Mr. Welsh at 1937 escalates his behavior to what I describe as active resistance, puts his arms down and starts moving away from the officers. He starts physically resisting. At 1937-19, Mr. Welsh escalates his resistance and starts becoming physically combative with the officers. He raises his fists and attempts to swing. At 1937, he continues his combative resistance. Officer Conrad discharges the taser for the first time. The taser discharges were ineffective and they did not have any controlling effect on Mr. Welch. You can see him swing his arms, and at this moment, 1937, as I mentioned, the taser discharges appears to be ineffective. Mr. Welsh becomes physically violent, and you can see in this video, he makes an approach with his right fist clenched and attacks the officer. In 1937, Mr. Welch continues his physical resistance as the officers were trying to control Welch. He continues to resist violently and actively. You can hear the officers verbalizing with Mr. Welch to get on the ground. And they're physically trying to put him on the ground with a great deal of struggling. Officers continue to verbalize with Mr. Welch. Tell him to get on the ground. At 1938, as the officers were trying to gain control and handcuff Mr. Welch, the officers applied pressure and weight to his arms, legs, and body. We all heard the audible call from Mr. Welch saying he needs to go to the hospital, but he continues his physical and violent resistance while he makes that comment. He says he can't breathe, but yet again continues his resistance against the officers. Mr. Welch, at 1938, continues to resist. Miller discharges the taser. The force in this case continues to be what I'll characterize as objectively reasonable. The officers are trying to overcome resistance, and based on their training at the Pima County Sheriff's Department, applicable Arizona state law, and the United States law, overcoming his resistance is a lawful, objectively reasonable use of force based on their training and experience. At 1938, Welch continues to actively resist. Miller discharged the taser, and again, the continued use of force for the very same reasons, given the level of resistance put forth by Mr. Welch, is objectively reasonable. The struggle continues. You hear a verbal command for him to get on his stomach. At this point, the officers are trying to control Mr. Welch and apply restraints. He continues his active resistance. Conrad stuns Mr. Welch again in an effort to gain compliance. Verbalization continues. Welch continues to actively resist. Conrad drive stuns Welch to gain compliance. Drive stun is, for definition, the mechanism in which the taser no longer has any cartridges in it, does not have any neuromuscular incapacitation effect on an individual, and is merely a pain compliance technique used to overcome resistance. Taser's been applied. Commands continue to be given, verbalization on the part of the officers, yet Mr. Welch continues to physically and violently resist the officers' attempts. These officers have a responsibility to take control of Mr. Welch and place him into his cell. At this point, they continue to struggle to do so. At 1939, Welch continues to resist. The force used by the officers is consistent with applicable laws, the policy of the Pima County Sheriff's Department, applicable Arizona state law, and also the United States law. There is a moment of quietness here. I want everybody to take note. At no point do you see the officers kick, strike, punch, or escalate their behavior because they are, for the momentary, getting some compliance on Mr. Welch. The officer's response is in direct reaction to what Mr. Welch is doing at this moment. There's communication that he's been handcuffed. And they're trying to put, given the level of spitting and saliva coming out of Mr. Welch's mouth, they want to put a spit sock over Mr. Welch's head. Again, this is consistent with the officer's training, the policy, the Pima County Sheriff's Department, and the use of this type of device, if you will, is in accordance with Arizona state law and the United States law. Again, as Mr. Welch ceases his violent resistance and combativeness, the officer's actions are proportionately in response to what Mr. Welch is doing. Again, I want to point out, there's no kicks, punches, or strikes on the part of any one of these officers at any time. Well, we always expect our officers to not use the profanity or to always have professional courtesy. Of the thousands of use of force cases that I've reviewed in my career, it's very rare unfortunately, very rare that we have such a case. And not one case did I hear an officer utter a word of profanity in this incident. I thought that was very reflective of the officer's professionalism and the compassion they were trying to put forth in dealing with Mr. Welsh. Now at this point here, Mr. Welsh is handcuffed. He resists being placed in the chair. Conrad drive stuns Welsh an additional time. Again, the drive stun technique is because there's no longer a cartridge in the taser, and that taser merely offers a pain compliance technique which may or may not be felt by Mr. Welsh. In this case here, it appears that, again, the taser continues to be ineffective. It's unknown to what degree Mr. Welsh is feeling the effects of the taser, or because of movement, it's not being properly applied. That being the case, although handcuffed, you can see they're trying to control his foot, and Mr. Welsh continues to try and stand up while seated in the chair, offering a level of resistance, and the officer's use of force, even while handcuffed, is in accordance with their training, their procedure, and consistent with Arizona law and the United States law. At this point, it appears they've got Mr. Welsh under control. He stops moving. They're holding his head. And from this point further, we will not see any additional applications of force, and they will soon ask for medical assistance because he appears he's starting to become unresponsive. The officer's training, policy, Arizona law require them to maintain control and order in a jail facility. They had an obligation to control Mr. Welsh. It was not an optional choice for these officers. They were obligated to take physical control of Mr. Welsh. They had to overcome his violent resistance, and the actions of these custodial officers, based on any reasonable officer's training and experience, the level of training and experiences those officers had, is objectively reasonable under the law. And that was ultimately my conclusion and my opinion that I put forth to Ms. Conover in the Pima County. And with that, I'll bring Ms. Conover up with me and you can answer any questions.
Again, my obligation here in assessing whether criminal charges should or could be pursued is whether there is a substantial likelihood of conviction. In addition to what we just viewed, where every use of technique to gain compliance is in response to continued physical refusal to comply by Mr. Welch. In addition to that, I had to also consider the autopsy report that is publicly available and lists 4 causes of death, 4 contributing factors: physical resistance, cardiovascular disease, obesity, and methamphetamine toxicity. With those 2 factors combined, we are not at a substantial likelihood of conviction. And that's where the conclusion rests today. We will take your questions. We'll do our best to determine whether I can answer the question or whether our subject matter expert should answer the question. This is why you bring in experts. This is certainly not my area of expertise. And I appreciate you being here, Deputy Chief.
I'm Adam from K-Gun. Can you tell us about your meeting with his family and what their reaction was to you guys not bringing charges?
I'm definitely going to protect their privacy. I would never want to speak for them. I can only speak for the amount of grief in my own heart. That's all I can speak to.
Andres from KLOD. How many times was Mr. Welsh tased and how many times was he stopped?
So Mr. Welsh was tamed. The taser was discharged a total of 7 times, and I was advised on the part of counsel, given the pending litigation, further details about the taser I don't want to get too much into. However, I will say that it's available it'll be available in the report that will be eventually released, or can be garnered through appropriate public records request. But a total of 7 times, and in each of those cases, it did not have the desired effect. And in all 7 of those applications, it was my opinion that it was objectively reasonable under the circumstances, given the level of physical violence and resistance that Mr. Welsh was putting forth against those officers.
So I want to add some helpful information. I think there are 2 courts of law, so to speak. We are here to talk about whether there's a substantial likelihood of conviction for criminal activity. There is an entire other discussion where all of these important critical facts will play out in the civil realm under a civil case. And we can't comment on that because that is pending. But to clarify the answer, I think, about the taser not working, and to the extent that active resistance continued despite the taser being used, I'll refer you back to the 4 causes of death, which do not include taser.
John with Arizona Luminaria. So not asking about criminal charges, but as a policy expert, were there any things that happened in the video that you saw that you think could have been done better or not done to policy? And a couple that I want to ask about. One is, he was actually in the room alone for a moment early on in the video. Could they have closed the door? Would that have been a more appropriate response? Or another one, he called for medical help a few times. He said, I can't breathe. He said, I need to go to the hospital. He said, I have a heart condition. I think among a couple other comments. Should they have requested medical? Because I think from my watching the video, they only do so after he is laid out on the floor.
John, I really appreciate these thoughtful questions. And I think even in your question, you clarified the distinction that, generally speaking, could have done better does not mean committed crime. And that was the decision that was before me. And all of the questions that you just asked, no doubt, will play a massive role in the other realm of the civil litigation, and that case has been sent out. So our civil attorneys are not working on that case, but because it's pending, we absolutely need to refrain from commenting on that. And I know that's frustrating for us both, but to be honored.
Question for John. Just nationwide, we're just seeing a pattern in regards to law enforcement. When somebody resists arrest, somebody gets on top of them, they say they can't breathe, they're tased, and then sometimes they end up dead. Do you just overall think just nationwide there needs to be a change in the technique to restrain somebody?
Well, every single law enforcement use of force is very unique in its nature, and each one needs to be judged on its own merits. To the instance where there's been other like incidents that have resulted in death, those are remarkably different instances. And in many of those cases, the use of force by the officers was not objectively reasonable. So it's really difficult to paint every law enforcement use of force with any type of broad brush, because every incident is usually, quickly developing. They're dynamic. They're operating under very tense and uncertain circumstances. So it's really difficult to really say something generally. But in this case here, it's its own case. I looked at it on its own merits, and the officers' actions were, in my opinion, were objectively reasonable based on their training, the policy of the Pima County Sheriff's Department, Arizona law, and ultimately the federal law.
Again from KLD. When Mr. Welch was found unresponsive towards the end of the video, how long did it take for medical services to arrive to help him?
I can't say that I have memorized that particular answer, although I'm sure the video will give you additional time. But Andres, I did want to note that the video actually ends with a call to the sergeant for medic. In other words, the call from the officers could be considered immediate. We actually saw that. That was the last word that we saw before we pressed pause.
And a follow-up to that, for John, as part of the training system, you looked at the policies, and are officers trained to provide CPR and new medical services, or is that only for medical professionals when they arrive on the scene?
Well, both. They are trained in CPR, and when they determine that CPR needs to be given, they have been trained to do so.
Another follow-up on this. So was that the first time that we saw at the very end of the video that someone called for medical help?
I'd rather not go off memory just at this moment. I myself would have to refer back, so I just don't want to. I can't say for certain off the top of my head right now.
But you have, like, or Mr. McMahon, you have assessed that?
But repeat the question again about the time of medical.
When someone called for medical help.
Yeah, medical help was recalled. It's documented in the video and in the help, and I'll let the facts speak for themselves.
Well, I have another question. Don't want to take all those space, but Tamara, so it's been 16 months, or maybe over, or right about 16 months since this happened. This seems to be a new process going, and this was through the Pima County Regional Incident Team. Is that right? Initially, and then to your office. Do you feel satisfied with the timeliness of this? Leaving the family hanging, as you said, they were distraught. I've spoken to the family multiple times as well. They felt left in the dark, as they told me. What's from your side? What do you think about how long this has taken?
A family who has lost a loved one, the amount of grief cannot even be contemplated. Am I aware of it? Is it a factor? Absolutely. And in spite of that, I have to proceed deliberatively. PCRIT, as it's referred to, the Regional Investigation Team, they proceeded with every detail, and so they took several months before the investigation reached our office, and then we took additional time to deliver the most thorough review we could possibly give, and breathing in that independence and neutrality of hiring an expert from out of state. That causes delay for all the right reasons. In other words, would we like to deliver news to a family in this kind of situation more quickly? Yes. Do we want to make errors in rushing to that? No, we cannot. We can't be influenced by emotion. We have to get it right. And that's critical for public trust.
So you say, like, use of force cases like this might take a year and a quarter, a year and a half going forward as well, or are you going to try to speed them up?
Well, I think again, when we rush, that's when errors happen. So we're definitely going to look to avoid that. This is a fatal incident. So when you look at the length of time that we take on all homicides, we take every homicide equally seriously. This may have taken even longer, given some complexities, but homicides don't run quickly, and it's something that we have to warn victims about up front at the beginning of any homicide case. I'm certainly extremely pleased with our homicide team. When we walked in January of 21, there was a backlog of 144 homicides going back to 2017. That's how long some families had been waiting. And I am thrilled that now at Homicide Panel on Mondays, we're looking at late 2022, early 2023 cases, but they take a long time. Absolutely.
I have a question. Laura, you said that some things. You said that some things may have gone better, could have been done a little differently or better. Mr. McMahon, are there any recommendations that you may want to give the Sheriff's Department after reviewing this incident?
I've never seen a case that has ever been absolutely perfect, but that doesn't mean it's a case that's been out of policy or the officers had done anything wrong. My comments about it being in compliance with the procedure and law are exactly that. But when it comes to other procedural things that can be seen or things that can be done better, I always feel obligated to point those things out because there's learning lessons to be had in every incident, and this is no different.
And I'll add that we try to be the best partner that we can be in sharing information, but at the end of the day, again, the county attorney, myself, I have no control over the jail. I have no control over those policies or training or procedures. I have no authority, and it's because I'm the county attorney and not a district attorney. So I am the county's attorney, and that's structurally why this is set up this way.
So you said that things could have been done better. I understand that you can't share that with us, if I'm understanding you right. But have you shared it with the Sheriff's Department, or are you going to?
We're gonna let all of this play out in the other court of law. I'm here to talk about whether criminal charges could be filed or not. And I'll take another question.
Yeah, given what you said about being the county attorney
Right.
and not pressing charges here and the high level needed to bring charges against police officers and corrections officers, can you explain what you think your campaign promise that you signed means when you said you would hold police officers and corrections officers as accountable as the general public if you don't think that that's something you can actually do, since you keep insisting that you have no authority over the jail?
That's an excellent question. If there was sufficient evidence to get that substantial likelihood of conviction, we would absolutely be prosecuting, and we've already shown our ability and backbone to do that. And that is the problem. No, for those who didn't hear, she said once, and so I will now be pulling the data on excessive use of force, and because for families and for the community, it's not just when a fatality has occurred. Unacceptable use of force, excessive use of force, has to be handled very seriously. And we have successful trial results. And I need to be educating on that to continue to build public trust.
Because this is not how the general public is normally treated, with over a year-long investigation, and in fact, most of the people that you're prosecuting who are dying in the jail are all pre-trial, and yet they're being, including Wade, who was pre-trial.
Right.
They are not given the same type of things.
If the question is, does Arizona state law pack in additional protection for law enforcement? The answer is there are statutes on the Arizona books created by the legislature that create additional obstacles when we are assessing whether or not we can reach that substantial likelihood of conviction. And we've seen how that plays out in Arizona.
Yeah, data would be great just given your signed campaign promise.
Absolutely.
This is not.
Absolutely.
The wording is a little misleading in your campaign promise to hold these folks as accountable as the general public.
I appreciate your opinion, and I'll be getting you data to disabuse you of that.
Great.
We'll get there.
Okay.
Thanks so much. Any other questions?